law from NYU Law School and subsequently completed a PhD at the National University of Singapore, which is where he's been teaching for the last 2 years. Many of his comments and contributions are given a fair amount of visibility, have acquired a fair amount of visibility and are discussed, as we said, both in the classroom and outside the classroom. And it's an invaluable opportunity for us to listen from a person of his experience, especially unique because he's able to integrate his previous experience as a practitioner with the kind of career track that he's now chosen as a full-time academic. So it's a great privilege for us to hear from him, and we hope that you will also participate and make the best of this interaction.
Thank you, Siddharth. And it's indeed a pleasure for me to be here this morning. And I would like to thank the public policy group of NALSA, who've been very enthusiastic in arranging for this visit to come here. So this is my first visit to NALSA. It's been many years, but I'm really glad to be here for sure. And thanks to all of you for being here on a Saturday morning. It's always difficult to get people, and I was mentioning to some of them, it's not a problem with NALSA or a problem with India, it's a problem everywhere. So, but I hope you take away something that your Saturday morning is going to be worthwhile today. So, what I'm going to be speaking about relates to matters of public policy and policy making, because the idea here is to try and understand how corporate law policy has evolved and how law has been made. So what I'm going to do today is probably to take you through a historical journey to see how corporate law has evolved in India and what are the policy challenges and the policy imperatives that have driven corporate law making in the country. And that's really the basis of what we're going to look at today. So what I'll do is I'll keep going on for a bit, and then maybe we'll have a little bit of Q&A session at the end. But please do feel free to stop me as I'm going through. If you have any questions or comments, I'm happy to address them as we go along. But we'll certainly leave some space and time at the end for discussion and Q&A. So please do feel free to raise your hand and stop me as I go along. So let me begin with some academic or theoretical discussion or provide a framework within which we can have this discussion. So how does law evolve in different countries? How does law develop in different jurisdictions? And I'm just using corporate law as an example to try and examine some of these policy imperatives. So what is the importance of corporate law in different jurisdictions? So there's one thesis which has been bandied about quite a bit since the late 1990s. Some of you may have come across this thesis or this theory. It came out by a group of, it was brought up by a group of economists whose acronyms start for LLSP. Right? So to be honest, I don't know the names of all four of them, or I can't recollect them offhand, but they are called the LLSP. They are basically a group of economists situated in the West who basically said that legal origins have an important role to play in the development of capital markets. So they said the more evolved a legal regime is, there is a greater likelihood that capital markets in those countries will also be fairly evolved. There will be liquidity in the capital markets, there will be more retail investors in the capital markets, so long as the legal institutions have been set up in a desirable way. So that's really the thesis that they came about. They came up with. But their thesis is a bit controversial for another reason, which is that they did not stop with what I just mentioned. They went one step ahead and was able to demonstrate that common law systems do better than civil law systems when it comes to protection of investors and development of capital markets. So what that basically means is that jurisdictions which follow common law would have better capital market institutions than countries which follow the civil law approach. because corporate law evolved in the pre-independence era effectively as a transplant of corporate law that was present in the UK for colonial reasons that we all are very familiar with. Because corporate law at that point of time was transfused from the empire to the colonies around the world. So that's the second point that we need to think of. One is the legal origins, and the second is the legal transplants, which resulted in diffusion of corporate law into various countries. And the third question that I'm going to talk about also is what happened to corporate law in these jurisdictions after independence. So if there was a transplant and the transplant was not supposed to work properly, then there should have been a change post-independence. And we look at India as an example as to what was the impact of corporate law in the post-colonial era following independence. So that's a question which we are interested in as well as we move on. So the basic point of this talk and this lecture is first to demonstrate that corporate law in India began as a legal transplant from English company law or English corporate law. But what we find subsequently, especially post-independence, and not immediately after independence, but in the years following independence, that corporate law in India has decoupled from corporate law in the UK. So we see a legal transplant and then we see a decoupling of sorts. And I'll explain all of these with some examples as we move forward. But the decoupling is something that we see in the later stages post-independence. And what is current corporate law in India? Current corporate law has nothing to do with transplants, but current corporate law is more to do with solving problems that have arisen locally within India. So if you look at the 2013 Companies Act, there is some vestige of the old Companies Act continuing, but wherever corporate law has changed in the 2013 Companies Act, they are all to solve local problems. And I'll demonstrate these two examples, but that's really the philosophy of what we've seen happening. So what started off with a transplant has ended up ultimately as a local solution to problems that we see in the Indian context. So that's a big change that we see in the evolution of corporate law at a broad level. So when you think about looking at local problems and local solutions, that is something which is very different from the concepts of convergence and transplant that we see that had occurred in the previous few years. So that's really what we need to map out as we go along, and that's really the core of what we see in this lecture as well. So let me go back to the source. Let me go back to the beginning. What exactly was the policy imperative for the evolution of corporate law to start with in the Indian context? Now, even though we've had the East India Company established in 1600 in India, almost until 1850 there was no statute governing company law. So for almost 250 years, there was some sort of company in India, primarily the East India Company, but no legislation whatsoever, because companies were at that time referred to as charter companies. So they had to get a charter of the legislature or charter from the crown in order to carry out companies, because corporate law was not the way it was or it is currently. But the first legislation in India we see is in 1850, and from 1850 until 1936, company law has changed several times. And I'm not going to go through each of those changes because it's all too detailed, and some of you who are interested in it may find it in the paper which has been circulated to you. So there have been a number of changes that took place in the historical era. We are not concerned about what those changes were or how many changes are there, but what we are more concerned about is why those changes occur. So why did those changes take place? And it's very clearly possible to correlate the changes taking place in the UK with changes taking place in India. So every time there was a new legislation in the UK, within a few years, the Parliament in India would also legislate on a new corporate law that was applicable to India. So you see a direct correlation between what is happening in the UK and what is happening in India, which is consistent with the legal transplant theory from the empire to the colonies. But why did this transplant take place? Transplants take place for many reasons. One of the simple reasons why transplants take place is the cynical reason could be that the legislature is lazy. Right? Rather than come up with a new solution, why don't you simply adopt something that's been tried and tested elsewhere? Why do we want to rock the boat? Why do we want to reinvent the wheel? Right? That would be the reason why there could be legal transplants. But in this case, the policy reason or the political economy behind transplant is a lot more than that. The transplant relates to the fact that a lot of the business that was going on during that period, the pre-independence period, was happening between, not just within India, but it was happening between English companies and Indian companies, or English businesses and Indian businesses. So, if you want to promote English businesses in India, the best way to do that would be to set up a legal regime that English businesses are comfortable dealing with. Not only that, that English businesses are familiar with. So, if you set up a legal regime in India that looks similar to what is there in the UK, then it would promote and generate business between English companies and Indian companies. Right? So that's one reason that's been thrown about as to why there was a legal transplant, because it promotes interaction between businesses among different countries, but also between England and India. And the second consequence of this approach was also something that was very interesting, which is that there was a very free market economy that was prevalent during that period of time. So if you look at the legislation in company law of those periods, they are what we would today call default regimes, where company law gives you a default regime that you can carry out or you can opt into so as to get certain benefits. Right? So it's a facilitative process. So corporate law is a facilitative mechanism whereby it allows people to carry out business using this particular vehicle or mechanism called a corporation. So it's a very free market, laissez-faire type of arrangement, as opposed to something that's very regulated or prohibitive in nature. So you see a lot of free market aspect coming in, and that's also consistent with what was happening in the UK at that point of time, because that is the time that there was a lot of boost in industrial activity in the UK, and consistent with the free market economy and the laissez-faire approach that was taken in the UK, you also find a similar pattern adopted in India. And just to give you one example of why I say it's a free market or a laissez-faire economy, some of you may be familiar, but I suspect most of you will not have been familiar with this. India used to have this concept called the managing agency system, and which no longer exists. And what happened in today, those of you who have done corporate law will be familiar with the fact that companies are under the superintendence and control of the board of directors. Right? The board of directors are responsible for carrying out activities relating to the company. But in the managing agency system, it was completely different. So, if people think that outsourcing was a new phenomenon, they are wrong, because outsourcing existed even in the 19th century. So what companies effectively did was their boards of directors would not take full responsibility. They may be responsible for it, but they would not carry out all the functions relating to the company. They would outsource it to this entity called a managing agency, which would itself be a private company or it would be a partnership firm. So effectively the management of the company was outsourced to a different entity. And that entity would be an agent acting for the principal, which is the company itself. And many of you will be familiar, the more you outsource something to an agent, the principal always has to ensure that the agent is sufficiently monitored, because the agent would otherwise act in the agent's interest as opposed to the interest of the principal. So this is the theory of fiduciary responsibilities. Right? Agents are also fiduciaries. That is better said than done. In law, we know that agents are fiduciaries, but how do we ensure that they act in the interests of the principal? That is going to be a big problem. And there, the criticism of the laissez-faire approach of the times is that these managing agencies have a free hand. right? They would pretty much control the company as if it was their own property, for instance, and therefore that caused a lot of problem because the managing agents would benefit at the cost of the shareholders of the company. So the kind of corporate governance problems that we're thinking about today was also existing at that point of time, and no one ever really curbed that practice. Now, you might think, and this is where policy issues come in, right? There are many ways by which you can curb this kind of activity. We, as lawyers, sometimes we think regulation is the answer, right? So there needs to be regulation that curbs these practices that have been emanated from this kind of activity. So that's one possibility. That regulation did not exist because of the reasons that I mentioned, right? Everything was going fine, everybody was happy, there was nothing to regulate further. The second question from a policy perspective is, if regulators don't curb on this, can market not correct itself? Why would these shareholders keep investing when their money is being taken away by these managers? Now, unfortunately, I don't have an answer. At least the historical facts do not suggest that there was actually a market correction which corrected this problem. And this is something that I'm quite interested in, and I'm kind of looking at it in the future as well to see how we can get to the bottom of some of these problems. But these are some questions that continue to operate from a historical perspective that we do not have an answer to. But we know that the laissez-faire situation that existed at that point of time gave rise to such situations, such as the managing agency federation. But it was only until the pre-independence time, that is post-1936 onwards, that this whole legal transplant question started changing. So post-1936, but even before independence, slowly, when the Companies Act was amended, for example, in 1936, there was a Companies Act of 1913, which was amended in 1936. There were curbs that were introduced on the managing agency system. And why were those curbs introduced at that point of time, which didn't exist for 150 years before that? Again, that's an important question to think about. But one policy consideration that's come about is, by then, a lot of Indian businesses and Indian shareholders became influential in the political process. Right? People like the Birlas, Tatas, etc. became quite active in the political process, and they were having their own managing agencies, mind you. But at least they were conversant with these kind of problems that arose. And perhaps the greater Indian influence in the political process in India perhaps brought about some check in the managing agency system, because a lot of the managing agencies were owned by British businesses. Right? So there was a lot of this nationalistic and ethnic questions as well that arose during that point of time, during the consideration of what to do with managing agencies. So the point that I'm trying to make here in this, using this example of managing agencies, maybe it's the right example or it may not be the right example, but there are so many different things that go into policy making, right? Not just the question of do we want to regulate, but also how do we regulate, do we leave it to market factors, and also these questions of nationality and ethnicity as to who exactly is the constituency that is running these institutions become important questions. So these are the considerations that existed in the pre-independence era, due to which we see substantially free market economy in corporate law making, which is starting to get curbed in the pre-independence era. Now coming closer, we need to think about what was happening at the turn of independence and after independence. And that's quite interesting as well when we think about the making of corporate law and the policy considerations there. Because one significant thing that occurred after independence was, as all of you will be familiar, India's move towards what we call a mixed economy approach. Right? So the free market economy kind of got curbed because under independent India, the first government was very keen to develop states' involvement in business and not give businesses a free rein. But what was interesting at that point of time was also, and this is something that I hadn't gotten to the bottom of it until very recently, is there were a lot of dynamics at play. So this mixed economy didn't come about just like that. because even within the Congress government at that point of time, there were different constituencies and approaches. So, for example, Nehru was very keen to have the Fabian socialism approach adopted in India, whereas there were constituencies like Sardar Patel within the Congress party who actually wanted to have as much free market as possible. So what we see in post-independent India is this kind of compromise arriving in the form of a mixed economy. And the question then is, how does all this translate into the making of company law? And this phase in Indian history of corporate law is important because this particular dynamic is what gave rise to the 1956 Companies Act. And the 1956 Companies Act is it's a very important piece of legislation in India because it is the longest standing piece of legislation in India. So there's never been a Companies Act that stood as long as the 1956 Companies Act has. It's probably lasted almost 60 years. But more important, it's also got amended several times. I don't have the actual number, but it can run into several amendments that have happened during the period. But how the 1956 Companies Act came about is also quite interesting. Because what happened in 1956, or before that, when the Act was being considered, you would normally think that because we have a mixed economy with a strong socialist element, corporate law will be fairly regulative in nature, right? So there will be a heavy sense of regulation in corporate law because of the mixed economy approach. But if you look back to how the 1956 Act was enacted, that was not the case. Because the 1956 Companies Act was a result of a consultation process through a committee headed by C.R. Baba. So there was a Baba committee report in the late 1940s, early 1950s. And that committee report did not take into account any of this transition to the socialist economy. What that report basically did was almost on all sections of the Companies Act that was discussed, they simply decided to adopt the 1948 Companies Act, which was there in the UK. So we would think that the transplant would come to an end after independence, but that was just not the case, because the transplant continued even after independence. And the 1956 Companies Act is yet another very important example of the legal transplant, without having regard to what the social and economic situation was. So there is a bit of an aberration, according to me, when you look at the 1956 Companies Act, because it just doesn't gel with the political economy of the period. But that aberration was fairly quickly corrected, because from the but at the same time, the other thing which baffles me is some of you would be familiar with things like the industrial disputes. There's the IDRA, right? Industrial Development Regulation Act of 1956. That was very controlled command economy, whereas the Companies Act, which was passed the same year, was not so. So there seems to be some kind of a gap in the policy making, which can be explained or cannot be explained, as I suggested. But whatever it is, that got corrected pretty quickly, because in the 1960s, the Companies Act started getting amended several times. And the amendments from the 1960s onwards are heavily focused towards the socialist economy. So even though the 1956 Act is a kind of an aberration, it underwent significant amendments since 1960 onwards, all of which started becoming more and more socialist in nature. And I'll give you just two examples of what happened in the 1960s and 1970s. So some of you may be familiar, there was a concept known as a deemed public company. Right? So companies are divided generally into public and private companies. And the philosophy for public and private companies are very, very different. Right? Public companies may end up taking money from the stock markets, they may be listed, they may have large number of shareholders, so they need to be subject to greater regulation. Whereas the philosophy for private companies is very different, because private companies are almost like partnerships. They are between a small group of people who are known well to each other, concept of a deemed public company, whereby many private companies would also be regulated as a public company if they are of significant size, if their turnover is significant, or if they are significantly owned by other public companies. And this is something I can safely say fairly unique in the Indian context, because in most other jurisdictions, private companies are private, public are public, but here we have this dichotomy or this kind of a strange relationship where sometimes private companies also become public companies. So that's an example of how even what we think of as otherwise subject to private relations between parties is now being brought under a heavily regulated kind of domain. And some of the vestiges of that continue even today. So some of you may be familiar with this issue of restrictions of transfer in articles of association. Right? It's supposed to be applicable mainly in the context of private companies, but sometimes public companies also get caught within it. The 2013 Act has tried to deal with it. Maybe it's not entirely satisfactory, but these are some examples of where you see correlation not taking place sufficiently clearly between public and private companies. The second example which I want to mention is how the courts deal with this issue. And that's very interesting. And for those of you who are interested, there is a National Textile Workers case. It's a 1983 Supreme Court case, judgment by Justice Bhagwati. I think it's National Textile Workers Union versus P.R. Ramakrishnan. It's a very interesting judgment. And in this judgment, the judge actually tries to explain as to why, given these changes in the philosophy of company law, even the courts need to start thinking about a company differently. So there is a private law understanding of what a company is. A private law understanding of company that corporate lawyers like us subscribe to is a fact that a company is nothing but a relationship between certain actors. And those actors are the company itself. The company is a legal person. The company, the shareholders, the directors, these are the relationships that company law should be concerned about. And sometimes we also refer to it as the nexus of contracts theory, because company law is nothing but a nexus of contracts among all of these constituencies. So, under that perspective, company law is nothing but a private law concept. Do you have a question? Do you have a question? So, company law is nothing but a private law concept. But what this judgment and the amendments did was they moved it into the public realm. So the concept of public interest was introduced into company law. So company law no longer is a matter of contract between private parties, but the essence of companies, the activities of the company, the operations, the implications, the impact has greater relevance to society, and therefore Justice Bhagwati says, no, we can't think of a company as something that is very private law oriented. A company has an impact on society, therefore we need to think about it from a public interest perspective. And that has taken very deep impact in the Indian context. And to me, to a large extent compared to any other jurisdiction in the world, because public interest is now an important element of several things under the Companies Act. So if you want to do a merger between two companies, the court which is approving the merger, among other things, also has to look at whether the merger is going to affect public interest in any way. And some of you may be familiar with the Hindustan Lever case, early 1990s Supreme Court, where the court said yes, public interest is an important aspect. Even though a merger is a contract between two companies, it has public interest impact, and therefore that has to be considered by the court. So very important distinction, right? So our notions of how we think about a company has changed from how it has initially evolved, and how the legislature as well as the judiciary has thought about it in the later part of the 20th century, and that's something that we need to keep in mind fairly significantly as we move on. So to me, a lot of these changes are important, and to me, they are probably also not given as importance from a philosophical perspective as it should be, because to a lot of times corporate lawyers and contract lawyers tend to look at things technically, not from a broader the time between the 1960s and the 1980s. But as you're all familiar, something happened in the early 1990s, which is the new economic policy and liberalization. So I was actually living through that process because I was in law school, and we saw how everything changed very differently when this occurred. And it was very difficult to kind of, even for us philosophically, to adjust to things, because we all grew up in this era where, it's all the state, it's the socialism, it's a great thing, but we didn't know what else was there, right? But after 1991, everyone was exposed to what else. Indian industry was exposed to what else is out there, because till then Indian industry was kind of free from external competition. We could not buy Coke to drink in the 1980s because we could only get thumbs up. But after 1991, things changed, right? So Indian industry was also exposed to foreign competition. And to me, as an external observer of Indian industry, the way I would put it is, I think the response of Indian industry was pretty interesting as well. The first response was, we need to be protected, right? This foreign investors are going to come and gobble us up. We need protection, so let's not open up all sectors of the economy. Let's bring in this liberalization, but it has to be a gradual process. It cannot be an opening up of the economy all of a sudden. And that's understandable. And if you see the policies of, especially on foreign investment, etc., in the 1990s, it's very, very gradual. Even though foreign investment was allowed, some of you may have come across, there was something called the Press Note 80. And what Press Note 80 basically says is that if a foreign investor had a joint venture with an Indian company and the joint venture is terminated, the foreign company cannot start its own business in India without getting a no objection from the Indian partner. So if I'm the Indian partner, I'm in a very nice position, right? So how are the negotiations going to go for termination? The Indian party has an upper hand, because either the foreign party wants to terminate if he wants to leave India and go forever, which is fine. But if the foreign party wants to leave the joint venture and start another business in India, the Indian party is in a very good shape, because they have a better negotiation power and leverage. I can extract a lot of friends through this process. And interestingly, this Press Note 18 and the follow-up of that didn't go away until like 2-3 years ago. But these are some examples of how there was some kind of protectionism that continued. But at the same time, we started seeing examples where Indian industry started facing itself up to foreign competition, not just the foreign competition, but also Indian industry wanted to play at a global level. So why did Infosys for the first time list its American depository receipts on NASDAQ in 1999? The reason was Infosys wanted to show that it's a global player. It's no longer an Indian company. It is a company which is willing to play on the at the global level, but also be subject to global standards. Because if you list on the NASDAQ, they have to be subject to all the corporate governance requirements that companies listed on the NASDAQ are subject to, and therefore they are making a statement by saying that we are going to be now subject to, or we are prepared to be judged by corporate governance standards that are at an international level. But in this kind of a scenario, what was interesting from a corporate law, corporate governance perspective, it's a slightly reverse dynamic that applied from a policy perspective. At this level, it was not the government which came and said we want to impose higher standards of corporate law, corporate governance. In the 1990s, it was Indian industry who voluntarily said we want to be subject to higher standards of corporate governance. So in the 1990s, you had the company law, which was a basic legislation, you had the Companies Act, but the CII, the Confederation of Indian Industry, in 1998, came out with a voluntary code saying that some of our members have got together and said, we want to be subject to a standard which is higher than what the Companies Act provides. And why would anybody do that? Why would anybody be subject to higher standards of governance? There could be many theories about that, right? One theory that people bandy about, especially in the US, is people universally agree to higher standards of governance, because if they don't do so, they will be wrapped by the government with something which is even more onerous than that. Right? So take the financial crisis, for example. What happened after the financial crisis in the US? There was something called the Dodd-Frank Act that was enacted. But sometimes, from a regulatory policy making perspective, there is a theory which says that sometimes industry itself voluntarily agrees to higher norms because of the fear that regulation could be even more severe than that. But that is not the idea that I attribute to what Indian industry did in the 1990s. Indian industry did that because higher corporate governance norms would attract better foreign investment. Right? It goes back to what the British businesses were doing with India. If foreign investors are comfortable with the level of governance in Indian companies, then they are more comfortable investing. And if the governance principles are familiar to them, if it's similar to what they follow in their own countries, then they are more comfortable investing in Indian companies. So the reason why these companies voluntarily agreed was the more higher your governance norms are, not only can you attract more foreign investment, but you can also attract foreign investment on better terms. Because there is sometimes a concept called as a governance premium or a governance discount. Right? If a country has better governance, then governance premium would suggest that foreign investors would pay more to invest in that country. And governance discount is exactly the opposite. If the governance in a country is very bad, then people will discount their investment and pay a little less in order to invest in a country. So the idea behind what happened in the 1990s was, you see this whole voluntary mechanism in order to attract greater governance premium and foreign investment, which then led to the government also following the same approach. So in the 1990s, you see the companies themselves carrying out higher corporate governance, but that was quickly followed up by SEBI, which came up with what is called Clause 49 of the listing agreement. Right? So Clause 49 of the listing agreement prescribes governance norms for public listed companies that was basically modeled on what the CII came from. So voluntary governance norms became mandatory. Once SEBI came out and said this is a good thing, right? Why should only a few people follow it voluntarily? Let's mandate it for all public listed companies. So that is what happened again in late 1990s, around 2000. And then we see this evolution of corporate governance from 2000 until now, right? So there's a lot. So if you look at, if you Google for corporate governance with a date of 1995 in India, you will probably not find many results. But if you do a Google search for corporate governance today, you'll be flooded with information. And that's the kind of change that's taken place in India in the last 15, 20 years or so when it comes to corporate governance. But the very interesting dynamic that took place, and this will be my last part of my time scale analysis, right? Which is how did all of this result in the 2013 Companies Act? Right? What was the policy imperative for the 2013 Companies Act? And this goes back to sometime in the 1990s, where the 1956 Companies Act got amended so many times, and it was becoming an unwieldy legislation. So the government started thinking about, let's have a modernization of company law, and let's come up with a completely new legislation on company law. So from the 1990s, people have been thinking about it. There have been different bills that I don't think any of them were presented in Parliament, or even if some of them were presented in Parliament, it didn't go forward. But it's only around 2005 that there was a serious discussion about revamping corporate law. And that discussion came about and was facilitated through a committee which was appointed by the government under the chairmanship of Mr. J.J. Irani. And many of you may know who J.J. Irani is. He's a senior member of management of the Tata Group. Right? So, who is spearheading this intervention? The intervention is coming from industry. I'm not saying that the chairman of the group is going to decide everything, but at least the leadership was in the hands of industry. There were also members from other constituencies as well. But this was to a large extent an industry-led initiative to come up with a modernized company. And how do you think the it would be fairly in favor of the ease of doing business, right? Fairly industry friendly. I'm not saying that there is rent seeking involved here, but at least the idea of company law would be to ease the doing of business. So the committee presented its report, and based on the committee's report, there were companies' bills that were presented in Parliament. So I think the first bill that was presented was the company's bill of 2008. And the 2008 bill was very industry friendly. And what happened in 2009, there was a general election, and obviously that bill lapsed, and there had to be a bill of 2009 that was to be presented in Parliament. But something important happened between 2008 and 2009, which was the Cyrill scandal, right, which rocked the country. So Cyrill scandal involved more than $1 billion of financial fraud, and the more curious thing about Cyrill is nobody discovered it. The chairman had to come and confess in order to bring this whole fraud into line, and this to some extent shook up the whole law-making process. And why was Cyrill important? Firstly, the magnitude of the fraud, $1 billion. And I hate to be cynical, but frauds of high magnitude have happened even in the past. But why this fraud? Why was it important? This was important because it related to information technology, which was and continues to be a very important industry for India. It's a service-oriented industry where credibility and trustworthiness is very important. So the moment you find a fraud in an industry which is servicing customers overseas, that's going to paint India in a very bad light. So because of this and several other reasons, I'm not saying that this is the only reason. Because of this and several other reasons, the 2009 version of the company's bill went to a standing committee of Parliament. And who comprises the standing committee of Parliament is mainly the members of Parliament. So a document which was initially looked at and considered and proposed by an initiative which is strongly composed of industry players now was left with the political class. Right? The political class was looking at this document, and then you see the dynamics completely change. And what does the political establishment have to do? They have a constituency to cater to. One of which is to say, if there is an important event like this that happened, you can't let that event go. How do we improve our laws and rules in order to make sure that an event such as this does not occur again? So it was the 2009 bill that went to the committee. When the committee came back with its recommendations, the nature of the document completely changed. So what was essentially an industry-oriented approach turned out to a very heavily regulatory approach. So the concept of independent directors, audit committee, related party transactions, so everything that is very regulatory was included after the discussions with the parliamentary standing committee. So you see how the dynamics change during this law-making process. So today what we have in the 2013 Companies Act is what I would call a kind of a mishmash approach, where you see a lot of this coming into play. You have this industry approach, plus you have these concerns raised, which also have been catered into, and that's really what resulted in the 2013 Companies Act. And many people thought that it might not get passed, but somehow it got through very quickly, and like many other bills of this nature, without very much discussion in Parliament. But the point is, what are the features of this? And the paper has all the details about what kind of provisions, etc. I'm not going to go into the details, but I'll just give you the flavor of one or two things that changed in the parliamentary committee discussions. The first question is the distinction in company law between what you call as a shareholder-oriented approach and a stakeholder-oriented approach. Right? So directors of the company have to govern the company in whose interest? The company is a fiction. The company is a legal entity, but they have to think about somebody's interest behind that legal fiction. And historically, it's always been the shareholder. Right? Under the shareholder-oriented approach, shareholders' interests are more important. And the best example of this approach is a US case. I think it was a court in Michigan in 1990. It's a case called Dodge versus Ford. What happened in Dodge versus Ford was, all of you know Ford Motor Company, right? Ford Motor Company decided to offer a discount to sell some of its cars. And the moment you start offering discounts, you see that there is going to be a transfer of value from the shareholders to the customers, right? Because the customers are benefiting from the discount, but shareholders are getting less profits. So some of the shareholders of the company went to court, and the court said no. The role of the company is actually to look at the interests of the shareholders. The offering of the discounts was against the interests of the shareholders, and therefore you cannot offer such discounts. So this is an example of a heavily shareholder-oriented approach, where everything about company law is to look at shareholders. But one of the things that happened in the 2013 Companies Act, and those of you who are interested can look at section 166 subsection 2 of the 2013 Companies Act. It very clearly says that the directors have to act in the interest not just of shareholders but also of creditors, employees, and even uses the word community. Right? So the role of the directors is enlarged substantially. It's not just to shareholders, and this is consistent with what we see in the 1980s Supreme Court approach, right? Where the role of a company is much wider. It's not just about shareholders, it is also to consider various other interests, including other stakeholders. So today, if I'm post 2013, and this provision has already come into effect, if you are a director of a company in a Ford versus Dodge kind of a situation, your role is going to be very precarious because there's no clarity. You have to consider all of these interests in order to exercise and discharge your role and functions in the company. So this is a very important change that the 2013 Companies Act has carried out. And interestingly, this also came up in the debates in the 2006 Companies Act in the UK. But the UK said, no, we're not going to go down that route. So UK came out with something called the Enlightened Shareholder Value Approach. It's called the ESV. And in the Enlightened Shareholder Value Approach, all of these interests have to be considered, but with a view to protecting the interests of the shareholders. So there's a hierarchy. All interests have to be considered, but if there is a conflict, shareholders' interest is paramount. But in India, there is no hierarchy. All of the interests are equally important. And that's something called the pluralistic approach. So India has gone further than what even the UK has done, which is going to make it fairly difficult for the directors, but the philosophy is important for us when we are discussing here, because you see a complete change in the way things have arisen. And the second thing which India is very well known for after the 2013 Companies Act is this concept of corporate social responsibility. So both the stakeholder approach, corporate social responsibility are only examples of the kind of changes that have occurred post-discussion in the Parliamentary Standing Committee, where you see the impact of scandals taking place and bringing greater regulation and changes to the notion of how we think of companies altogether. So one of the things that happened currently is how do we deal with all of these? Obviously, industry is going to come up in arms against too much regulation, and we know that the current government's goal is to, one of the goals is to move up the ease of business rankings that the World Bank comes up. So the question is, have we gone too far to the regulatory side after the 2013 Companies Act? So what is happening currently is that there is a committee that's been appointed by the government that is looking at softening some of the rigors of this new legislation. So the idea is to try and see, have we gone too far, have we become too prescriptive, have we become too, are we making it too costly for companies to carry on business? So what we see, and this committee came out with a report I think about a month ago, which was chaired, I forget the name of the chair, I think it's a retired judge or a bureaucrat, and this committee report is available on the Ministry of Corporate underlying philosophical direction which the company laws take. It's still very regulatory, but they're just chipping at some of the marginal issues to try and soften the blow. But the basic direction which company law has taken is still continuing. And this morning's newspaper, I read that this committee report has also has evoked a lot of comments from people, and that they're going to form another committee to look at the committee report that this committee has made, and I don't know where it's going to end, but that's pretty much what's happening. So in a nutshell, I'll stop here, and I'm happy to take questions, but before I stop, I think the key themes that I want to draw, this talk is not about technical aspects of corporate law, but to try and establish what considerations from a policy perspective went into the making of corporate law and evolution of corporate law at different points of time. And for those of you who are looking at it from a political economy perspective, there's always this theory called the interest group theory. Right? So at different point of time, you see different interest groups having an influence on legislation. And a lot of what we see in the evolution of company law in India is also consistent with these dynamics that we have seen so far. So a few of the things to think about is firstly, just because, going back to the legal origins thesis that I started off with, just because a country is from a common law or civil law family, it doesn't make all of the difference. Right? There are other internal dynamics that we need to keep in mind, and some people refer to it as the path dependence theory. Right? There are some factors within each country that stay forever, that will never change. And how much ever you try to converge or transplant is not going to make that much of a difference. And I guess this study that we have seen in the current discussion as far as corporate law is concerned only solidifies that argument, at least my opinion. And so I guess there is still a lot of scope for further thinking on some of the micro level issues. I've only painted a broader picture, but at the micro level there are many other issues that we need to think through. And I guess we all need to put our collective heads together to think about it. So let me start with that, and I'm happy to take questions. Thank you.
First of all, thank you, sir, for this wonderful insight. So my question is,